Evee Perich and Emma Phillips from Queensland Advocacy Incorporated. That's QAI, to those in the know. Evie is a social work master student and Emma Phillips is a systems advocate and lawyer, and they'll be assisting us to look at different aspects of consent and the law through examining Section 216 in the Criminal Code and its unintended consequences for those deemed to have quote-unquote impairment of the mind. So please make them feel very welcome.
Thanks very much, Leona. And I too would like to acknowledge the traditional owners of the land on which we meet today and pay my respects to their elders, past, present and emerging. I'd also like to acknowledge those with lived experience of sexual violence and their bravery in sharing their stories, including Sarah, who we've heard from today. So Queensland Advocacy, like Women's Legal Service, we're also a specialist community legal centre. Our focus is on protecting the most vulnerable people with disability and mental illness. So we've got a little bit of a different focus there. We have done a lot of work around violence and abuse against people with disability who are particularly vulnerable to experiencing violence and abuse, including sexual violence. And as you've heard from other speakers earlier today, there is quite limited data on these types of issues, particularly data specific to Queensland. But some research has shown that people with disability have a 90% chance of experiencing violence or abuse in their lifetime, and over an 80% chance of experiencing sexual violence and abuse in their lifetime, which is really absolutely staggering. Some of the recent work we've been doing around violence and abuse against people with disability includes, we were heavily involved in the 2015 Senate inquiry into violence, abuse and neglect of people with disability, both in putting a very lengthy written submission outlining what reforms we wanted to see in that area, and also appearing before the Senate committee. We're currently working on a national position paper with Australian Lawyers for Human Rights about violence and abuse. And we've just got a fledgling project which we're currently getting up and running about violence and abuse of people with disability in their homes. And that's something that Evie's been working on with us during her time at QAI. Today, though, we're going to talk about a slightly different issue. We were asked to talk about issues relating to consent in this area. And so the issue we're speaking about is part of a law reform campaign that QAI has been involved in with other organisations around Section 216. And it's a good example to use today, I think, because it really shines a light on some of the complexities associated with consent and in particular capacity to consent. The section that we're talking about today, and it criminalises abuse of people with an impairment of the mind. And so what it says is that any person who has or attempts to have unlawful carnal knowledge of a person with an impairment of the mind is guilty of a crime and liable to imprisonment for 14 years. It also creates some other related offences, such as unlawfully and indecently dealing with a person with impairment of the mind, unlawfully procuring a person with an impairment of the mind to commit an indecent act, unlawfully permitting him or herself to be indecently dealt with by a person with an impairment of the mind, willfully and unlawfully exposing a person with an impairment of the mind to an indecent act, etc. So there's some related offences around it, but essentially it's criminalising the behaviour of sexual abuse of persons with an impairment of the mind. looking at how this section actually works, there's not a lot of information about what Parliament was thinking when they introduced this section, and it is quite an odd section of the Criminal Code. From the way it's written, it's clearly designed predominantly to protect vulnerable people from sexual exploitation or abuse. And because it's directed in this way, the definition of capacity to consent is very relevant, which Julie spoke about. That comes from section 348 of the Criminal Code. And it defines consent to mean consent freely and voluntarily given by a person with the cognitive capacity to give the consent. So it's quite a black and white understanding of how consent and how cognitive capacity works. Now, some of you in the room might be aware that QAI published the Queensland Handbook for Practitioners on legal capacity. So capacity is something that we've had quite an interest in because of our work with many people who have or are alleged to have impaired capacity. And one of the main points we have emphasised in this handbook is that capacity is fluid, it's not fixed, and capacity is time-specific, it's domain-specific, and it's decision-specific. And also, and very importantly, that capacity can be increased and maintained with appropriate support. So we don't agree with the way this section works in terms of making it you have capacity or you don't, and the presumption is that if you've got an impairment of the mind, language we also don't agree with, it's very, very dated and not appropriate language in our view, but that if you do have an intellectual or a cognitive impairment, then the starting presumption is one of lack of capacity rather than capacity. And I'll speak shortly about how that fits with human rights law. So we think that the initial assumption should be that people do have capacity and that with appropriate support, and that support that's chosen by a person that they're happy with, that capacity can be maintained and can be increased. And so we don't think it's appropriate to frame these Section 216 offences around capacity, particularly where it's understood in such a limited way. Instead, we think that the law should recognise that some people, including obviously people with intellectual or cognitive impairment, do have particular vulnerabilities, and the law has an important role to play in protecting all people and giving particular protection to people who do have particular vulnerabilities. But that in protecting these people, the law can't then place limits on the right of any person with an intellectual or cognitive impairment to engage in sexual relationships, and to make the implication that there is something inappropriate or unlawful about a relationship in which one or both people have an intellectual or cognitive impairment. And that's what we think Section 216 does. And in our view, this comes down to some extent to some of the limitations with the design and drafting of Section 216. So the substantive offences that are created by that section and then the defences to the section sit quite uneasily together. There are two defences that are found within Section 216. The first comes down to the reasonable beliefs of the alleged perpetrator about whether the person with whom they'd engaged in sexual relations with had an impairment of mind. So that's quite similar to one of the defences to the general sexual assault provisions that Julie was outlining. And the second defence stops someone from being criminally liable under the section if the person wasn't sexually exploited. And so, in my opinion, that's all well and good. This is what the law should do. If someone hasn't been sexually exploited, then the other person shouldn't be found to be criminally liable. But to me, that seems a bit of an inversion of how it should be. That really should be the starting point. It shouldn't be something that someone charged under 216 should have to prove. Also looking at how Section 216 sits with other provisions of the Criminal Code, and it's a good position to be in this late in the morning, as long as everyone's still awake, but because you have had a good, I think, a good overview of some of the other provisions of the Criminal Code that deal with rape and sexual assault. And so you can see we do have those provisions. They're separate, independent provisions of the code. So to create this as a separate provision is a little bit odd. The law also does prescribe circumstances of aggravation, which is essentially where an offence is to be more serious because of the circumstances in which it was committed. And so, in my opinion, a more appropriate way to provide this quite specific and focused protection for people with particular vulnerabilities would be to make heightened vulnerability a circumstance of aggravation, which is triggered once a serious offence, such as rape or sexual assault, has been committed, not to make a separate action that criminalises sexual relations involving a person with intellectual impairment. Does that distinction make sense? I'm just going to speak briefly now about how Section 216 fits within a human rights framework. As most of you in the room are probably aware, Australia has signed and ratified a number of international human rights treaties which set out the core human rights which all people should enjoy. And I'll just speak in a little detail about a couple of human rights that are particularly relevant to the right of all people, including people with disabilities, to live an ordinary and inclusive life. The first is the right to bodily integrity, and this is a right that all people should have protected, because bodily integrity is essentially the right of a person to have their body protected from violence or violation. And this human right highlights the importance of personal autonomy and the self-determination of human beings over their own bodies. So that's really considered quite a fundamental human right. Another human right that is fundamental and particularly relevant in this discussion is the right to freely form relationships, including marriage and founding a family. There's a number of other key human rights that are particularly important to note in the context of this discussion. The presumption of capacity, which, as I've said earlier, really should be the starting point for all humans. The right to inclusion, the right to equality and to non-discriminatory treatment, and the right to privacy. And some of these human rights are considered so fundamental that they're expressed and protected by a number of different human rights treaties. And I put some images of some of these treaties that are particularly relevant for this topic today. The Convention on the Rights of Persons with Disabilities is obviously the most relevant for people with disabilities. The Convention on the Elimination of All Forms of Discrimination Against Women, which is CEDAW up there, the Universal Declaration of Human Rights, which isn't actually an enforceable treaty in its own right, but it's sort of considered the source of many of these fundamental human rights and freedoms. So essentially the yardstick by which our human rights are measured. The Convention on the Rights of the Child, and then to a lesser extent for this conversation, but the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. So we have signed and ratified these treaties which commit Australia to protecting these human rights of all people. Yet this isn't actually being done. And I'll speak a little bit more about that now in terms of some of the unintended legal consequences that do flow from having Section 216 within the laws of Queensland. Firstly, what it does is it renders many naturally formed and consensual sexual and intimate relationships unlawful. There are not a lot of instances of actual prosecutions under Section 216, but there are certainly cases where it has been prosecuted. And our concern is that simply by having that provision in the code, its very existence does cast a shadow over any relationship where one or both persons do have an intellectual or cognitive impairment. We think this section is in breach of some of the human rights obligations, which I've just outlined. It's also inconsistent with both state and federal anti-discrimination law. And I think this is a really important point because people with disability and all people have the human right to equality. This is considered a really fundamental human right. It's not only expressed in these international human rights treaties, but it is actually specifically incorporated into our state and federal laws through the anti-discrimination laws. Now, Section 216 of the Criminal Code discriminates against people with disability by limiting their ability to engage in sexual relationships in a way that it doesn't do for people without disability. So that is discriminatory. And if we contrast the treatment of people with disability under Section 216 with a very topical example, the right of same-sex couples to marry. Now that's obviously something that's currently subject to public debate, but happily the right of gay people to engage in sexual relations that's not criminalised, it's not under debate at the moment, and we think the same should apply for people with disabilities. And our concern, and this concern is eventuated in some cases, is that the criminalisation of sexual relationships under Section 216 can lead to the use of restrictive practices, so the application of chemical restraints, seclusion, isolation, those sorts of practices because of behaviours that can be related to natural sexual expression but that are considered behaviours of concern. The prescription of anti-libidinal medication or forced or coerced sterilisation, and the making of forensic orders, so where a person with disability or a mental illness comes into contact with the criminal justice system and a forensic order is made, and that in turn can then lead to potentially indefinite detention, which is another issue QAI has done a lot of systemic advocacy around, labelling people as a sex offender, and removing children from parents with intellectual impairment, which is also an issue that's really of significant concern to us at QAI, but is a topic for another day. It's a bit outside the scope of what we're speaking about today. So I'll hand over to Evee now, who's going to talk to you about some of the social consequences.
Hi, I'm Evee, and I'm on my final placement at QUT for my Masters of Social Work, so I can't tell you how intimidated, I meant excited that I am here today, because I know that not many students are given this opportunity. So my interest in understanding violence brought me to study social work, which attracted me to systems advocacy, which thankfully led me to do my final placement with QAI. These past 3 months at QAI have opened my eyes to all types of violence inflicted against people living with disabilities. However, today I'm not going to be talking about sexual violence, but I am going to be talking about sex and legislative restrictions to intimacy, which is, when you think about it, yet another form of violence against people living with disabilities. So I'll see if I can work this thing. Aha. So firstly, to start off with, I just wanted you to think about these questions. As a human being, what does intimacy mean to you? How does touch affect us as human beings? What does it feel like to be loved? I'm sure if I asked anyone in the audience today any of these questions, the room would be filled with words like cherished, loved, validated, alive. So on the flip side, I'd like you to imagine what a life would be like without intimacy. And how would you feel if your sexuality was not only ignored, but was denied and criminalised? So today I'm taking inspiration from Salt and Pepper. I'm asking you to don on your double denim and let's talk about sex. Now, it may be a little bit awkward and I may break the record for the amount of times that sex is mentioned in a presentation, but it's something that we all need to talk about. Sex and intimacy is a conversation that we all need to have, regardless of our age, our sex, our sexual orientation, absolutely regardless of disability. However, people are still being excluded from these conversations. And here in Queensland, this idea is so entrenched in our intolerance of the sexual lives of people with disabilities that some human beings are being actually written out of these conversations by our very own criminal code. Now, we've all just heard from Emma about the unintended legal consequences of Section 216. But now I'm going to be looking at it from a slightly different angle, and it's the unintended social consequences of this piece of legislation. How does the action of criminalising intimate relationships with Queenslanders with intellectual impairments affect their participation in society? Now, laws can uphold rights, but they can also prohibit access to those rights. Section 216 was designed to protect the vulnerable from sexual exploitation, which is a good thing. Everyone in this room is well aware of the fact that people living with disabilities are more likely to be impacted by sexual violence than people without disabilities. So laws to protect our most vulnerable are always a good thing. However, in the case of Section 216, where it is an offence to have sex with someone with intellectually impaired capacity, many legitimate, consensual and loving relationships are being ruled invalid and illegal. Section 216 is a double-edged sword of protection and prohibition, because unlike all other jurisdictions within Australia, Queensland is the only one not to adopt a consent-based approach to the law. This straightaway silences people with intellectual impairments and once again removes them from conversations about sex, intimacy and sexual well-being. So what happens when we don't talk about the sexual well-being of people living with disabilities? Or perhaps what we should be asking is, why don't we talk about sex and intimacy in relation to disability? As Emma discussed, rights to bodily integrity, as well as the right to freely form relationships, are human rights protected in international conventions. So why are we so afraid of these conversations? Like Emma also said, homosexuality in this state was decriminalised over 25 years ago. And today we're participating in a postal survey debating the rights of same-sex marriage. Yet here we stand today talking about the denial of basic human rights, of intimacy and sexual expression for people with intellectual impairments. The discriminatory aspect of this realisation is confronting, to say the least. Historically, our inability to talk about sex and disability has led us down a path of discrimination, institutionalisation, sterilisation and eugenics. However, even today as a society, we still struggle to separate the person from the disability. As an able-bodied person, I have the privilege of representing many different identities simultaneously. I'm a student, I'm a woman, I'm a friend, I'm a daughter, I'm a professional. Yet time and time again, when somebody has an intellectual impairment, their disability becomes their dominant identity. People with intellectual impairments are seen as eternal children and are labelled as either asexual or hypersexual and are always viewed through the lens of risk. We need to find a less oppressive way to talk about sex and disability without exclusively framing it in terms of vulnerability and abuse. People living with disabilities are entitled to have a relationship with sex outside of sexual victimisation. Otherwise, sex and intimacy becomes something that is only taboo, forbidden, and dangerous. Okay. Carry on. Unfortunately, this law represents the wider social and political beliefs around disability and sex, and this has devastating consequences on social participation and a person's right to engage in happy, healthy relationships. By avoiding conversations about sexuality and actively preventing access to things such as sexual education and sexual expression, we're actually increasing the risk of exploitation and abuse towards people living with disabilities. So not only are we disempowering people, we're actually making them more vulnerable. Instead of investing in conversations about sex, we criminalise consensual intimate relationships. Instead of involving children in conversations about puberty, we place our own comfort, convenience and paternalistic agendas first and commit medical violence, like forced or coerced sterilisation. Instead of participating in conversations about consent, we punish inappropriate behaviour with anti-libido medication and in some cases forensic orders, indefinite detention, and label them as sex offenders. Sex education and conversations about consent empowers people to understand and recognise abuse, which in turn reduces the likelihood of becoming victims, and also the possibility that that abuse will be normalised and repeated by breaking the cycle of abuse and preventing people from becoming future perpetrators of sexual violence. Instead of engaging in respectful conversations about healthy relationships, we create structural and political barriers around parenthood under the guise of protection to justify the removal of children from parents with intellectual impairments. Instead of talking about sex with people with disabilities, we silence them, rob them of their sexuality, leave them vulnerable to abuse, and deny them full participation in society. In 2011, all levels of government in Australia committed to the National Disability Strategy, which demonstrated a unified effort amongst the states and territories to improve the lives of people living with disabilities. The government declared that the idea that a person with disability would be more disadvantaged by society's response to that disability than the disability itself led to a greater need to focus on policies to remove these barriers. Within the 76-page document, 6 key policy areas were identified. So let's take a little closer look at some of these policy areas. Policy area number 2 covers rights protection, justice and legislation, which are topics that we're all talking about today. Initiatives in this area included the need to review restrictive legislation and practices from a human rights perspective. Sexuality and sexual rights are protected in international conventions, including the United Nations Convention on the Right of Persons with Disabilities. Section 216, a punitive approach to this law, denies these human rights. Policy area number 4, which covers personal and community support, including the person's right to inclusion and participation in the community, recognises the need for individual choice and control in connection to social relationships. The restrictive nature of Section 216 effectively removes a person's choice and control. Policy area number 6, health and well-being, which identifies enjoyment as a pillar of good health and well-being, calls for the development of evidence-based policies to remove the social and environmental barriers to good health. In fact, all the policy areas identified within the National Disability Strategy recognises the many factors that contribute to a person's ability to live a good and happy life. The National Disability Strategy states that the level of control an individual has over his or her own life can make a big difference to the quality of their life, as well as recognising that social participation and developing relationships are fundamental to the well-being and health of an individual. The existence of laws such as Section 216 further confirms that people living with disabilities have less ownership and control over their bodies and lives than people without disabilities. However, this issue is not only present in the sexual lives of people with disabilities, as it reaches into every aspect of their life, from access to healthcare, education, housing, and recognition under the law. Feeling connected is a human right. In fact, it could be argued it's what makes us human. Feeling disconnected to our community, to other human beings, leads to feelings of isolation and loneliness, which significantly impacts on our mental and physical health. The denial of an intimate relationship, if it is desired, contributes to these feelings of disconnection and loneliness. Studies have shown that mental illnesses such as depression and anxiety are intensified by loneliness. In addition to this, physical health concerns and cognitive abilities worsen when a person is isolated, because it is undeniable that loneliness has profound effects on our physical, cognitive, and mental health. As advocates, we must commit to supporting people to live full and inclusive lives, including sexual expression, which is why Section 216 needs to be amended to ensure that these discriminatory barriers are removed. Finally, I just wanted to say that in a space which is so often dominated with able people like me talking about the lives of people living with disabilities, it feels almost uncomfortable to be initiating conversations like these. I'm aware of how dehumanising these conversations can be, and I acknowledge that we continuously blur the line between private and public lives of people living with disabilities. I'm also aware of the irony of me asking you to speak publicly about sex in order to give the sexual privacy to people living with disabilities. However, these conversations are important. Yet, it must be acknowledged that my role as a future social worker, as an able-bodied ally, is not just to start these conversations, but to ensure that people with intellectual impairments have access to the same platforms that I'm now occupying. It is important that these platforms are used to talk about things such as sexual violence. And I particularly thank you, Sarah, for sharing your powerful story. But it's also important to talk about the social, political, and legal barriers to consensual relationships. I will leave you with a quote from a writer, teacher, and a self-advocate called Anne Figger. because people with disabilities should always have the first and last word about any discussion about their lives. Sexuality is often the source of our deepest oppression. It is also often the source of our deepest pain. It's easier for us to talk about and formulate strategies for changing discrimination in employment, education, and housing than to talk about our exclusion from sexuality and reproduction. Thank you.
I'm just totally blown away. Obviously. Oh, no, we have a question.
Sorry. Well, no, just a comment.
Comment, please.
I am actually aware of, just to contextualise this for perhaps some people, I'm aware of parents of people, well, two women with intellectual disability who have used section, or the fear of section 216 to go to the police to have a sufficient pressure and fear put on the couple so that they split up. The relationship was stopped by parents who take the eternal child attitude.
Absolutely.
Didn't want their adult daughter to have a relationship and used that sort of, you know, he's raping her situation to never went to court or anything, but it was sufficient to
Absolutely,
break
and
them
I
up.
think what's important in terms of contextualising some of the social issues as well is that I think for those in a position to provide services, if they're risk averse or looking for a reason not to engage in matters of relationship, sexuality, supportive relationship, then they will turn to this section of the code to justify that. And in a very technical sense, if you're the person who's on a board of a community organisation, and are you technically complicit in breaking the law? Are you meeting your, if you as an organisation say we will support people to do what they need to do to have the access to the information that they need, or the physical support that they might need to engage in a relationship that may or may not be sexual. So are you in fact breaking the law? If you are on a management committee of an organisation that would take that approach. So it's the cloud that hangs over the lives of people that, for those who wish to be risk averse or aren't game enough to address these issues, who will sort of turn to this as, I guess, an excuse not to engage in them. And I guess is the flip side of the way violence can manifest. So thank you for, I guess, taking on a slightly different angle there. I think it was, an interesting perspective to bring into that. And can I just quickly ask if people are interested in supporting your campaign, they can obviously contact QAI.